Members, good afternoon. We're also joined by the administration. This is the appointed time, and we have a quorum. So let's continue with the subcommittee's meeting. The first item on the agenda is meeting with the administration. We completed policy discussion at the last meeting of the 5th of June. The administration also provided a written response to issues raised at the last meeting, and please refer to paper number CB bracket 1639/2026 bracket 02. The subcommittee has also received 6 written submissions from deputations and individuals. The administration has provided a consolidated written response to these submissions, and please refer to CB bracket 1666/2026 bracket 01. The written response has been forwarded to members for reference, but let me invite the Commissioner for Labour, Mr. Sam Hui, and his team to supplement anything they wish in relation to the written responses. Thank you, Chair. Now, for the issues raised by members at the last meeting, we provided a written response. And perhaps I can supplement a number of points. The first issue of members' concern is about the definition of construction site and the delineation of boundaries. We provided different examples of works in the response for members' reference. Now, on the last occasion, members expressed concerns about the footpath underneath these bamboo scaffolding on the exterior walls of buildings. Now, we went back and considered the issue, and we provided a written response to clarify the matter. That is to say, if renovation works are carried out above the bamboo scaffoldings, above the footpath, and that no works are being carried out on the footpath, and that the footpath is only there to provide support for the bamboo scaffolding, and there are suitable measures to protect passers-by, then the area will not be regarded as a construction site. However, say if works are involved, or if materials are temporarily stored there, perhaps in the course of erection or dismantling of the bamboo scaffolding, so works are involved at grade, then there should be protection measures. That is to stop passers-by from going in, as it will be regarded as the construction site. Still, there may be members of the public inadvertently going into the area concerned or going underneath the bamboo scaffolding where works are being carried out. And for their own safety, we strongly advise them to keep the distance away from the scaffolding or to stop smoking there. The other point is about premises divided into sub-units or different partitions for rental. And I think as per our written response, we've raised some examples to illustrate under what circumstances the premises will be regarded as being exempted and therefore not a smoking area. Now, be it the landlord or the resident, if they engage a works contractor to carry out renovation works, then according to the members' concern, there is a question whether the landlord or the resident in question would be liable for any smoking offense in this construction site, as they may have management responsibility. As per our written explanation, the landlord or the resident themselves are not landlord of the construction site. So they have no construction site management responsibilities. Since they have engaged a contractor to do the works, it will be the contractors who would be responsible as the principal. And let me further clarify this point. As discussed at the last meeting, there was a question on whether accommodation provided to the workers on the construction site will be regarded as domestic premises. Now, we explained and illustrated our point with examples. By exemption, we refer to private quarters as defined by the law. There are two types. And that is to say, premises that are provided by an employer for the employee and his family, and that they enjoy exclusive right to occupy the living accommodation. So, for example, we have the type 1 private quarters, which means the quarters for staff quarters in general. But if the employer, for work purpose, provide an area for employees' shared use, then it's not regarded as private quarters. According to experience, if such an area is provided, usually the accommodation will fall outside the construction site and not within the construction site. Regardless of the location, since such quarters are not defined as private quarters, the workers staying there will not be exempted. That means it's still within the construction site, and that is a no smoking area. Now, there is also another type of facility, and that is for carrying out of duties or for workers to take a break. There may be accommodation for the short-term stay of the employees concerned, but it's not a place for a long-term stay or accommodation of employees. So these facilities will not be regarded as private quarters either. If we're talking about temporary lounges or rest areas in the construction site, then they will not be exempted. These are the points we responded to in our written submission in order to allay members' concerns. Now, there is also another point on whether we should allow a designated smoking area to be set up inside the construction site. I think we addressed that last time. I'm not going to repeat the point. And about helping workers quit smoking, I think very straightforward answers given in the written response, and that is we've continued to work together with the Department of Health and the Primary Healthcare Commission to support them in quitting the habit. We do not have any other information to provide, save to say that there are OSX-related activities that aimed to help construction workers and employees quit smoking. Perhaps later on, after we've completed scrutiny of this piece of legislation, we can provide further information to the panel for further discussion. As for written views provided by deputations and individuals in relation to the matter being scrutinized by the subcommittee, in fact, we provided a consolidated response. We covered these points at the previous meeting, so I'm not going to repeat now. Members, if you want to follow up on the reply just given by the Commissioner, then please press the button to indicate so. Now I see that 5 members are waiting to speak, starting from Aaron Barker, Chen Wing-kwong, Christine Fong, Chris Ip, Chen Hong-yan, and Charles Chung. We completed the policy discussion at the last meeting, so may I urge members to stay focused and just follow up on the written and oral responses given by the administration. I will give each member 3 minutes. Question and answer, please. Mr. Aaron Bok. Sorry, I think that we should allow further discussion of the policy, right? Actually, we completed the policy discussion last time, but if you have a follow-up question that is relevant, that means relevant to the Commissioner's response given just now and relevant to your concern, then yes, please go ahead. Well, Chairman, I think it all boils down to reasonableness. For smoking offense committed by the employee, you give out a fine of $3,000. For employers, it's 133 times up to $400,000, and you will also invoke the Factory and Industrial Undertakings Ordinance to prosecute the employer. This will affect the chance of the contractor winning bids again. So it's not reasonable. The purpose of the subsidiary legislation is to enhance safety. Imagine, for a worker working at height on the 30th or the 40th floor, will they actually go down to the street to smoke? I don't think so. They'd rather hide in a corner to do that, and that will be even more dangerous. The employer is supposed to be the site manager. There should be a designated smoking area with safety measures in place. Say, for example, every 10th floor you can set up a smoking area for proper management, because now you are just deflecting the problem. I think during implementation of the law, you definitely run into problems. Yes, Commissioner. About the responsibility, or rather the liability of the responsible person of the construction site, I already explained the situation last time. We set out the maximum penalty allowed under the subsidiary legislation, but it's up to the court to decide based on the severity of the contravention how much the employer should be fined. It could be ranged from several $1,000s to much higher. Well, of course, but we're talking about reasonableness, Chairman. Don't pass the buck to the court, because nowadays we have an employer being fined up to $10 million. You should make sure that at the enactment stage everything is reasonable. Don't pass the buck to the court later. I think Mr. Aaron Bok's point is clear. Commissioner, any response? Now, about smoking areas in construction sites, this is a rather complicated issue. We should not be too lax as to allow any site to set up a designated smoking area. There should be conditions to be imposed by the Labor Department, of course. And then what stems from this is the legal liability and the consequences of breaching these conditions. So it's very complex in terms of implementation. At the last meeting, we explained that we want to change this site culture of allowing workers to smoke in construction sites. We want to change this habit and this culture. This is a clear signal for everyone in society, but we're not rejecting this idea altogether.
Right, next, Professor Chen Wing-kwong. Regarding the administration's reply, I want to clarify something. For the definition of private quarters, in the reply, it is said that general quarters will not be regarded as type 1 quarters. But then for imported workers, they have to stay in accommodation in specific locations arranged by the government or in construction sites of the main contractor. So if we are talking about imported workers living in accommodation arranged for by the contractor in a construction site, will it be exempted? The commissioner talked about the accommodation probably not being in the construction site, but if it is in the construction site, does the contractor have to move the accommodation elsewhere? Or how will you deal with this situation specifically? I also want to ask about the definition of construction sites. I think the administration for providing more information on the definition so we have a relatively clear understanding. But I want to ask if the contractor has already implemented adequate measures in the construction site to prevent workers from smoking, for example, banning them from bringing ladders, construction site workers from bringing ladders, but they did not specifically designate a site boundary. Will the contractor be regarded as having contravened Regulation 53 and be made liable? My third question is, I do understand the administration want not to set up designated smoking areas. But as many members said, some sites are very large in size. For example, the 3-runway system construction works or the Northern Metropolis. If people have to smoke, they have to go very far away to smoke. That is not exactly practical. Have you considered for larger construction sites how can we implement the laws and how we can make it easy for the contractor to comply with relevant provisions? I believe the commissioner has addressed many of these concerns. Perhaps he can just give a succinct reply. Thank you, Chair. Well, if there are beds for workers, there is furniture, but there is no independent space for them to live in, it would be seen as quarters, even if it is in a construction site, so it is not exempted. I think the concept is very clear. As for the delineation of site boundary, it is actually applicable to all management personnel of construction sites because they have management responsibility. They need to make sure one without safety protection will not be able to enter the construction site. So this is something the person in charge of the construction site has to manage. It is not specifically related to smoking. As for whether to set up a designated smoking area in a construction site, I will not repeat this because I have answered the question many times. But regarding what Professor Chan said for the larger construction sites, these are special circumstances. We will have dedicated teams to take enforcement in such sites. We can coordinate with the main contractor on this, but in principle, we do not want to carve out exemptions in the law. Yes, Professor Chen Wing-Kong. I think if you do not carve it out in law, there will be gray areas. If you do not account for the larger construction sites now, you would just have this fight in court. Since you don't have designated smoking areas for the larger construction sites, for example, the Northern Metropolis, you can't. This is not practical, so you should make clear of that in law. Commissioner, I think you can perhaps talk about the legal concept specifically for the super large construction sites. Well, the concept is very clear, regardless of the size of a construction site. They should not have smoking on the construction site, we can have some sort of coordination. Based on the risk, we'll see whether we need to take specific enforcement actions and initiate prosecution. Ms. Christine Fong. Chair, the Commissioner actually said on the last occasion for private housing estates, if they are doing fitting out works in the unit will be seen as a construction site and smoking will be banned. But Labor Department officers may not be able to enter a private housing estate. If people dispose of smoking butts from the balcony outside, they will be charged for disposing items at height. But then I want to know in law, how can you make sure to practice proper management? Will you work with the Property Management Services Authority to make clear a particular unit is a construction site so that those on the same floor will know that fitting works are being done and smoking is banned? Will this be in law or in the guidelines? I just want to clarify this, Chair. All right, Commissioner. About enforcement powers to enter private premises. The occupational safety officers with the legislative amendments are empowered to enter private premises, so the member can rest assured. But regarding what Ms. Christine Fong said about how other people can be made aware that there are works going on in a particular domestic unit, I think that is a very valid point. We will work with the PMSA for coordination, and we also want to make sure property management offices are putting up signage or notices at entrances so that residents will know which parts of the building have works going on. Chair, I have a follow-up question. We have a fixed penalty where we have a notice specifically designating certain authorities. We have, say, officers from the FEHC and the Labor Department being able to take enforcement action. Say a construction site is very close to a public housing estate, or there's a park under management of the LCSC nearby. People will just move around and smoke in different places. What I want to know is if public officers can work together and there is some sort of coordination so that there can be joint enforcement operations, just like what the Water Supplies Department and Housing Department are doing. Commissioner. Well, of course, public officers have their different specific work areas, but the enforcement powers are actually not restricted by geographical constraints. I think this much is clear. Occupational safety officers don't only inspect construction sites, they may inspect restaurants, kitchens. So if someone is smoking in a restaurant, they can still initiate prosecutions. As long as they are designated as the authority, they can also enforce against smoking. Basically. Next, Mr. Chris Ip. Thank you, Chair. I would first like to thank the Commissioner for answering me a question raised on the last occasion on defining the boundaries of the site. But my other question was not answered. I think, like another member said, you are being too strict with contractors. So, say if a non-employee is smoking in a construction site, or a guest, or an other resident, if you hold the contractor accountable, that is very unfair and too strict. Of course, the Commissioner said if a construction site has been delineated. People shouldn't smoke there. But let's be practical. People don't care. If they smoke there, they will only be fined $3,000, but the contractor will be fined $400,000. I hope this can be rectified when we're scrutinizing relevant provisions. Perhaps you can make the scope narrower. The contractor should only be held accountable if it was an employee of the contractor smoking in the construction site. I think that would make more sense because, in a way, the company cannot control those who are not their employees. I think it would be very unfair to the contractor if there is some other party smoking. I hope the commissioner can directly address this question. All right. Whether the contractor should be held responsible when it's not their employees smoking. Commissioner, Chair, let me give you an example. For the contractor with their management responsibility, it would cover definitely their employees, but it should not be limited to their employees. Inside a construction site, everyone has to wear a safety helmet. If a construction site has an individual going into the construction site without any safety measures, the person in charge should be able to say whether the individual is a worker. If it is not a worker, they do not have the responsibility to manage the worker, but they need to ask someone to leave that individual to leave the construction site. Commissioner, I am just saying, for housing estates that are undergoing major repairs, there will be residents just passing by and smoking. The contractor can't really control them. I support a smoking ban being implemented. The thing is, people will do this, and the contractor cannot do anything about this. I think this is too strict, and this is impractical. Well, if we're talking about a non-employee, that a general citizen is smoking, can the commissioner explain if the contractor has taken reasonable steps? If there is someone, a general citizen, smoking, would the contractor be held accountable? Chair, I gave the example of one having to wear a safety helmet is to explain how the practice is similar for a contractor enforcing against smoking. Say, if it is a worker, the contractor has direct management responsibility for the conduct of the worker. They have to take reasonable steps to deal with this. If it is a general citizen or a resident, they may give the individual a reminder, or they can pass on the misconduct to the property management company or the labor department, so that those with enforcement powers or some sort of control to deal with the problem, as long as they have dealt with this in management, we would have regarded this contractor as having taken reasonable and appropriate steps. I think the concept is very clear. It's just like what I said earlier. With management measures in the construction site, it may not only involve workers, but for workers and non-workers, the person in charge can do something regardless because they have management responsibility. Mr. Ip, please be succinct. Well, since the commissioner said the contractor can make use of a declaration mechanism essentially to make clear what their responsibility lies, why don't you say in law they only have to manage their workers or employees? If you don't make clear of this in law, people will just have to make clear of this in court. That would be a waste of public money. Can't we just plug this loophole now?
Go. Commissioner, very briefly, please. Now, the concept is very simple. That is, whether reasonable steps have been taken. Depending on the features of the construction site, the contractor will need to take reasonable steps to fulfill the management responsibility. Can I take it that the contractor has control over its employees? So in a sense, more reasonable steps should be taken. For the general public, however, since they're not under the control of the contractor, you may not adopt as stringent a test of reasonableness. In all fairness to the contractor. Ms. Rebecca Chan. Chair, as a follow-up question on the policy issue, I'd like to follow up on 3 points. That is, in the written response issue C, we are concerned about renovation projects being carried out at domestic properties and that it will be regarded as a non-smoking area. In fact, in the third example, you will refer to one separate household unit, the flat being divided into more than one unit and that's subdivided flats. And then you explained by way of having works carried out in Unit A or Unit B. Well, we need to explain to the public whether it is or it is not an NSA. In fact, in the fourth example, you mentioned the common areas. Let's say the 2 units share a living room. Now, whether or not there is a resident in Unit A or Unit B, there will not be any exemption. But let's imagine you need to go past the living room before going to your respective units A or B. So that means it's an NSA as far as the living room is concerned, and you're not allowed to bring along your lighter or your cigarette when you go past the living room. Well, this is a real live example. You really need to be very clear when you illustrate this point. Is it that the domestic properties will be regarded as a site with home renovation and hence an NSA, and that if you go past the area you need to make sure you are not carrying the lighter or the cigarette? The second point is this. As I mentioned last time, this piece of subsidiary legislation targets construction sites and renovation projects. You want to introduce a comprehensive smoking ban. Last time I mentioned publicity and prevention and smoking cessation services. Now I'm turning to issue G in your written response. I'm afraid I cannot accept this answer. The cessation services and support measures are part of the overall health education and smoking cessation promotion efforts, and the expenses, resources for the services cannot be calculated separately. But we're talking about new legislation. We're talking about young people and a large amount of construction workers, and you just give us a simple answer as the expenses and resources not being able to be calculated separately. This is something that members here want to know. If you are not able to provide a separate set of figures now, you should at least be able to do that in the future so that you can apply for funding and more resources to help promote smoking cessation services. You need to go back and discuss with the health authorities. The third point is this, and I'm joined by other members. Other members talked about major construction sites, and I won't even point out the location. Say Northern Metropolis, the airport. I understand the legislative intent. In Hong Kong, we have an indoor smoking ban. There is no exemption. So in principle, I understand where you're coming from. There should not be a smoking area within construction sites. However, Commissioner, when we come to the scrutiny stage, we need to be very careful, because the Northern Metropolis is such a big construction site. There should be another way of dealing with the matter. Say, if it's larger than a certain size, then you may need to divide the site into smaller separate sites instead of designating smoking areas in construction sites. Because we do have some chronic smokers, we have rather aged construction workers who are so used to smoking, it is impossible. They will need to take transport in order to be able to smoke. You need to have regard to what happens in reality. Either you divide the mega site into smaller ones in order to fit your purpose, or there should be another way. Right, would the Commissioner please explain? Say for Northern Metropolis, the size will be as big as Yuen Long. Is it true that nobody can smoke there? Well, I appreciate your suggestion of a construction site being as big as a whole district in Hong Kong, but then there may be different works procedures going on within the site. And in fact, one construction site may come with very clear boundaries of what constitutes outside and what constitutes inside. So it's not appropriate to give a broad brush answer. In fact, there may be passageways between construction sites that allow personnel to go through. And this happens in mega projects, such as redevelopment of public rental housing estates or villages. For indigenous villages, we provide an easement that allows them to use the passageway, etc., etc. So there are different ways. As I previously answered, we need to have regard to the specific circumstances of these so-called mega sites and take a risk-based approach. But I think as far as the legal concept is concerned, is very clear. It's difficult to spell out the specific way of handling the matter in each and every circumstance for different types of construction sites. But I fully appreciate the members' concern. I don't think the question can be answered simply by allowing designated smoking areas within the construction site, because it is a very complicated issue. It will not be as simple as what you think. We need to have regard to the specific conditions of sites. What about subdivided units? Now, the Labor Department may not be the lead department concerned. You may need to collaborate with other government departments. You need to discuss the issue of subdivided units. I think the concept remains simple. For example, when you go back to your own home in a domestic property, you need to go past, say, the corridor, the lobby, and other common areas of the residential building. These are all non-smoking areas, despite the building being a private building. The common areas do not constitute part of your own domestic premises. So for the meaning of exemption under the provision, it's the same. For a flat with partitions, with a shared use or shared area, it remains a non-smoking area. And after you go back to your own domestic property and it's private property, that depends on whether works are being carried out and whether anyone is occupying the flat. Mr. Chao Su-chung. Chairman, according to the written response in paragraph B1, now it seems that the administration has delegated the task of demarcating the site to the contractor. So it's for the contractor to take this reasonable step of drawing boundaries of the construction site. But they need to follow the rules and regulations. For construction site, it means, under the law, a place where construction work is undertaken, and also any area in the immediate vicinity of any such place which is used for the storage of materials or plant used or intended to be used for the purpose of the construction work. I don't think the phrase immediate vicinity of any such place is clear enough. My point is whether you can further define what immediate vicinity means. You need to provide these details in the provision. And taking it further, if the contractor fails to mark clearly the site boundaries, for example, allowing materials to be stored within 100 meters of the site, or there may be a negligence involved, wrong marking of the boundaries, then will the contractor be held liable? Say if a member of the public steps in and smokes there, which is in fact part of a construction site, which should come with clear signage that it is in fact a non-smoking area, then this member of the public may be fined $3,000. But for the contractor, on the part of his negligence, will there be any reasonable defense available? Commissioner, the contractor responsible for the site should decide the site boundary is their responsibility, and that includes any area in the immediate vicinity of the site, because the area will be used for storing materials, for parking, and that they should be counted as a part of the construction site, because otherwise it will constitute unlawful occupation of the public place, and that the area becomes a public place that ordinary members of the public will have access to. So it's for the contractor to decide how much space is needed for the works procedures and to define the site boundaries and for demarcations to be made very clearly on the building plans. It doesn't just concern the smoking ban that we're discussing. It concerns the site management in general, because these are all related to occupational safety and health and safety at construction sites. So I want to reassure Mr. Chow that there are provisions relating to the OSH and construction in general, stipulating the contractor's responsibility. And we're not imposing any new requirements on the non-smoking area of the construction site. So if somebody mistakenly enters a smoking area and then, the construction site, and then smokes without reading the sign very clearly, then same as other measures applicable to a construction site or statutory non-smoking areas, there may be issues of unclear signs or people inadvertently entering a non-smoking area. So definitely the defense of a reasonable excuse will be available. Mr. Peter Show, my first question is this. Say if it's within working hours and if the worker smokes, then the contractor should be reasonable. Is there a time frame you have in mind? Say if it's non-working hours, the contractor should not be held reasonable. I think rather we should say that there should be proper access control for the construction site, because for non-working hours you should not allow any trespassers in. The question is whether this trespasser is coming in to smoke or to steal construction materials, and it's part of site management. Suitable measures should be put in place so that during non-working hours there should be proper supervision of the site to avoid trespassing.
Mr. Shilkafei, for new construction sites, I think it's easy to implement, but as members said, we may have 2 to 3 buildings in a construction site, and there are scaffoldings. When it's nighttime, workers or even the person in charge may be off work, but the construction sites are there around the clock. So if someone smokes there after people get off work, who is going to be made or who is going to be held accountable? Commissioner, if one entering the construction site is not a worker directly managed by the contractor actually has minimal management responsibility because they cannot control when the individual will pass through the construction site. I don't see how the contractor can take reasonable steps to prevent this from happening. If it is specifically a building where there are other residents, you can't really prevent access. So I think the contractor can only take limited reasonable steps, so there's also limited responsibility. Chair, I have more questions. Sure, Mr. Shu Kafei. Well, I know paragraph 13 of CB 1666/2026 the administration's consolidated written response to submissions. It is said the Labor Department will initiate prosecutions under the Factories and Industrial Undertakings Ordinance. I want to ask, will you only initiate prosecution after there is fire or simply when there is someone smoking? And the penalty is not just about the company being fined. They will essentially have a black mark on their record. And thing is, other companies may have their employees pose as the employees of the companies to smoke and affect their companies. It's a form of competition. It may be kind of a strategy. It can really affect the company concerned. All right, Commissioner, if there are some really serious circumstances under the general provisions, will one be fined $3,000? Well, I think the penalty is very clear. When we're going to initiate prosecutions may not be after an accident has happened. It may be before an accident happens and there's high risk of an accident happening and it can be detected and it was prevented with certain measures. We will see whether the circumstances are serious enough to quote the specific provision. But as Mr. Shu Kafei said, if we have some malicious conduct where people are trying to, or a company is trying to trap another company, this in itself is illegal. And we need to consider the worker who is planted as a mole, why they would do this. There will be an investigation, and in the process, those who should be held accountable will be held accountable. It's not a simple conclusion where who is to be held accountable. We have to look at the evidence and there should be an investigation. All right, next, Miss Julia Lau. I want to ask about the administration's response to issues raised about B10.1. It is said if there are no works on the pavement, it is not a construction site. But from the perspective of an AP, we won't have the same understanding because the scaffoldings are included in the plan and there will be insurance on this. It is going to be hard for you to say if there are no works going on, it is not a construction site. I think there's some sort of contradiction here. We need to really make clear of this. I want to also echo the point made by other members. The $400,000 fine is very much unreasonable. I don't know how they can justify this, but I do support a comprehensive smoking ban. We have had much discussion on this. We have a company plant molds in another company. We can just have the mold smoke, and then we will have some photos taken. Then the company will have a black mark on their record. Even if there is an investigation, it is hard for you to prove why someone is smoking in the construction site, and the individual won't admit they are a mole. I mean, it's impossible for them to admit that, really. I think in the business world, this is something that can really happen. Commissioner, I would say there is not so much conspiracy with contractors, but always there can be such possibility of enemies trying to sabotage each other, but I will not comment on this today. We are discussing policy issues. For scaffolding, sometimes they will go to the ground floor and there will be scaffold nets. Sometimes there is such need to undertake works, but the works are actually undertaken on upper levels. It's just that the support points are on the pavement, and there will be a passageway on the pavement. I do understand where the member is coming from. Insurance would cover those who are injured on the pavement, but then I think with the provisions related to the smoking ban, it is actually very clear how the demarcation of boundaries work. Thank you. Ms. Michelle Tang, I would apologize in advance, but having heard the commissioner speak for long, I still think there is no way that you have not addressed the questions raised by members. It is really unreasonable if you have to fine the employer or the management personnel of the site $400,000 when you only fine the smoking individual $3,000. Why can't you have a more deterrent penalty for those who are smoking? If you are fining them $10,000 or $20,000, they may stop and think about this. But if you're saying a few $1,000s, of course, a few $1,000s to a worker may not be a lot from your perspective, but I would say it is not deterrent enough for workers. I think you need a deterrent enough penalty for workers to really stop and think about it. As other members said, if one has taken reasonable steps, one would not be fined $400,000, but they would have to prove that in court. It seems that you are shifting the responsibility to the court. Why can't you make clear of this when you are stipulating the provisions? It seems like you may have some sort of difficulty, but then you did not make clear of this. You have given some responses, but you're just sticking with what you had. I think you really need to address members' concerns. Commissioner, I think the concerns are more or less similar. You can just give a succinct response. I can provide more information. We did not make any changes to the management responsibility of employers. The $400,000 penalty has always been there. $3,000 for smoking in a construction site is not a new proposal either. As for whether it is deterrent enough, we do not rule out the possibility of, after implementation, imposing a higher penalty to have a more deterrent sentence. I think we can explore this in future. We do not in principle object to this, but in general, the $3,000 fine is imposed on smoking offenses in any location. Let me add something. Please be brief. Well, you have to think about this. When we have to have another Wangful Court, do we have to wait for another Wangful Court incident for you to do something? Commissioner, as I said earlier, for high-risk locations or more serious consequences and circumstances, we would have the court hand out a harsher sentence based on the conduct. The maximum penalty is 150,000. We have 3 members wanting to speak for the first round and 3 members wanting to speak for the second round. If one has full questions or further comments in relation to the responses of the commissioner, please press the request to speak button now. I'll draw the line after Mr. Albertron has spoken. Thank you, Mr. Albertron. Thank you, Chair. The administration has said a lot, but I'm still quite confused. As many members said, for the boundary of construction sites, if you have scaffoldings, before the scaffoldings are assembled, you would have the scaffolds placed on the ground. So if, say, when a sign is being put up or when a facade is being fixed, if I am smoking, if there are scaffolds on the ground level, I may be punished. And as other members said, for the larger construction sites like the Northern Metropolis, not all workers there are construction workers. Some are there to deliver water or food, and they may already be smoking while they're driving. If they are caught, the contractor will be punished. The contractor may not have a designated courier for delivery of catering every time. So what do they have to do? Do they have to tell the catering contractor that they should not have someone smoking in the construction site as well? Commissioner, if there are several works going on, if there are construction materials, the area will be seen as having works go on, so it will be regarded as a construction site. If the contractor, when dealing with scaffold works, does not do anything to demarcate the site, not to mention someone smoking, but a general citizen passing by, if they are, well, if a bamboo scaffold drops, they will be seriously hurt. So the contractor must have management responsibility. I think many members are focusing on the act of smoking itself, but I think we need to make clear the fact that the contractors actually have the principal responsibility to demarcate their works boundaries. As for other personnel accessing the construction sites, the contractors also have management responsibility regardless of what kind of services they provide. And for a general driver, if they can just drive into a construction site at will, the site management personnel would have responsibility. We have 2 other members waiting to speak. Well, I have a follow-up question, Chair. Sure, Mr. Albertron. I want to say for bamboo scaffolds, when they're being assembled, there are still people walking on the pavement. For, say, in Central, they have only really narrow pavements. Even if scaffolding works are being undertaken, there would still be people walking on the ground level. I believe the Commissioner talked about this. You shared this example during the opening remarks. Well, I want to have members point out scenarios where there are pavements and pedestrians are walking by, there are safety risks, they can refer such cases to us. Well, I would want to say that there are different sites with different conditions. The commissioner has addressed different scenarios. I don't think he can address all scenarios because there can be hundreds of them. Regarding what members are concerned about the specific scenarios or those that are commonly seen in Hong Kong, I suggest members bring along pictures to show the specific circumstances so that we can more practically look at the scenarios. We are not changing the definition of construction sites. I think let's be pragmatic and make clear what the scenarios are.
Well, 2 more members would like to speak in the first round and 4 members in the second round. The queue stops here. Next, Mr. Zhang Puigong. I support construction sites smoking ban. I need to declare that I also work for a construction company. Now, earlier I asked a question about a fine of $3,000 for the offending employee and $400,000 for the contractor. Now, some members already criticized the penalty level as being too harsh for the latter. Say for the former, if the fine is too light, then it's not deterrent enough. As I earlier asked questions on dishing out leaflets for illicit cigarettes, the penalty level is so low. It doesn't pay to break the law. And this is an incentive. And then I also mentioned another scenario. Say if I bear a grudge, I'm not happy with my supervisor, and I will deliberately perform such an act so that my company will be fined $400,000. This could happen. And the question is this: when something like this happens, you will, of course, conduct investigation. And before the investigation is completed, will the company's eligibility for bidding future projects be affected? Well, I think members already talked about different scenarios, including the contractor being framed, the deliberate acts. Commissioner, would you like to explain? Now, for a contractor's prospects of bidding for projects to be affected, we're usually talking about complaints that are already substantiated or case that the hearing of which has been concluded. Whereas if it's an ongoing investigation, the status should not be affected. But like I said, it's all about reasonableness when it comes to responsibility of the site management. The first yardstick of reasonableness is the Labor Department's prosecution threshold. And that is, we need to substantiate the claim that the contractor fails to take reasonable steps. We need to collect evidence in enforcing the law, and this responsibility falls on the shoulder of the Labor Department. So once there is prima facie evidence, is for the contractor to explain by way of reasonable excuse that reasonable steps have been taken. Right, I'm the last one to speak for the first round. I think that it will be very important that you draw up guidelines. You need to illustrate how the liability of the contractor is absolved through taking reasonable steps. I believe that contractors will be relying on the guidelines in question to prevent themselves from being caught by the law inadvertently. And you will collaborate with the trade associations and other professional bodies in drawing up the guidelines. Now, before the Travel Industry Authority became a statutory body, the TIC used to issue guidelines as well. So will something similar be done? Because according to the FIU ordinance, there are guidelines on working in enclosed space, working at height on scaffoldings, or guidelines to prevent heat stroke. So what is the status of the guidelines? Will it be drawn up in collaboration with the sector? Will it be followed by the court? Is it binding? These are the questions. And also, why isn't the Labour Department issuing the guidelines instead? Commissioner. Well, actually, we do not rule out the guidelines being drawn up by the Labour Department for reference by industry practitioners. The guidelines will be drawn up on the basis of best practices, but we need to accumulate experience. So I think a good starting point is to engage the sectors for them to exercise self-regulation. And then we will extract the useful and effective bits to form part of the guidelines. Right, so I note that this is not really the guidelines prepared by the Labour Department, but in terms of enforcement, please make sure that you will review the guidelines on a regular basis. Right, we now open the second round as a number of members would like to make further comments. We need to make sure that we observe the time limit. I will give each member 3 minutes question and answer, but please be succinct in putting your question. Mr. Chris Ip. Well, Mr. Albert Zhuang asked a question, and this is exactly the case I raised last time and in the first meeting. However, the Commissioner gave a totally different reply, and I'm confused. I don't wish to further argue the point about site boundary, but indeed, in built-up areas in particular, be it Central or Yau Chim Mong, there will be bamboo scaffoldings erected that straddles the pavement. I want to make sure that there is a clear definition in the law in the future to avoid confusion. And also, Mr. Zhuang just now mentioned somebody driving and entering a construction site while smoking in the car. It's not part of the public place. Well, there may be different scenarios. And I'm not asking you to explain each scenario here. My point is it possible to ride on this opportunity and stipulate the responsibilities of the contractor? And you need to explicitly provide that the contractor is only responsible for the behavior of the employees, because the contractor may have an enemy. The enemy may send somebody to the construction site and smoke there. This is actually something we can foresee. We don't want any gray area. We don't want to leave this matter to the court for further debate. We don't want gray areas. Right, Commissioner, would you like to further clarify your answer to the same question? Chairman, I don't want to repeat, but may I ask Mr. Chris Ip to have confidence in us? Because when we talk about reasonable steps being taken under the law, we're talking about a rather high threshold of law enforcement in relation to different scenarios, different sites. we need to look at the specific case as to consider whether reasonable steps have been taken. The Labor Department has the burden of proof, so definitely for the scenario mentioned by Mr. Ip, they will have everything taken into account. They will not arbitrarily initiate prosecution, because the contractor in question will be facing a hefty fine. Commissioner, I have full faith in you, but the general public or contractors may not understand the position as well as the government, and this will cause confusion. Please pause and think, because you're putting pressure on the frontline enforcement officers. Please stipulate in black and white the responsibility of the contractor as well as other parties. Of course, the contractor is still responsible for stopping anyone from smoking, but I want to make sure that this is not a case of absolute liability. I appreciate that as well, and that is why I asked a question about guidelines issued by the Labor Department, and that a more stringent requirement may be imposed on the contractor's employees, but for passers-by, ordinary citizens, you just need to do this and that in order to discharge your liability. If you have the so-called official guidelines, then when this case is taken to the court, the contractor will be able to prove that reasonable steps have been taken to stop a member of the public from smoking there. So you really need to clarify the position. Commissioner, well, Chairman, this is exactly what I want to further explain. There may be different scenarios and specific management measures to be adopted. There may be different ways of handling contraventions. So when we work with the contractors and the trade associations, we will include these scenarios as examples in the guidelines, because the statute itself will not cover all the scenarios. Ms. Julia Lau, I think we need to differentiate between what the construction site boundary means and what the site of development means, because you may erect scaffoldings that goes beyond the site boundary. If you turn to the appendix, you will find that there are different kinds of works being carried out within the construction site. Say there may be the laying of pipes at some point, and once the works are completed, will you still regard the site as a construction site if no works are being carried out there? Well, I am actually an authorized person. I'm a professional, and I can tell you that the situation about bamboo scaffoldings, and it's really hard to define whether it's still a construction site. And when something like Wangford Court Fire happens again, it's very difficult to enforce the law. I raise this example because you need to define, for example, that the area remains a construction site until all works are completed. And I absolutely support Mr. Chris Ip's suggestion that the contractor's responsibility is to manage their employees and not the general public. You can just put up a no smoking sign there. Well, you may say that the idea of sending a worker to your enemy's site is silly, but when you do business, people will resort to different means in order to frame your enemy.
Commissioner, I do not have much to add, but regarding what the member said, there are always some sort of gray areas in terms of interpretation. So I want to make this clear again. If we have roadside works or scaffold works over pavements, to be safe, regardless of whether it is a construction site or not, citizens should not smoke in those places. Thank you. Last to speak, Ms. Christine Fong. Thank you, Chair. I do support a full smoking ban in construction sites. I want to ask about Schedule 2 of Chapter 371. We have some locations here. Say 0002, paragraph G, you have some karaoke establishment. But then we have some new venues such as venues for esports or pickleball. Will you include them? If you don't include them in the provision, will you include them in the practice notes? I also want to ask about 371 Schedule 2.8, say for the public entertainment premises. Will the East Dam, for example, a tourist attraction, be included? If it is not included in the provision, will it be included in the practice notes? Because there are quite a number of trees there. With the public municipal ordinance, we also have some no smoking areas designated. Will we include petrol filling station? If it is not covered, what will you do about this? That's my questions. Thank you. Well, I would say the legislative amendments proposed on this occasion are quite simple. Basically, they're just including construction sites to be covered under the Smoking Public Health Ordinance. They do not change the existing list. Apart, other than that, I am not sure if there is a construction site in the East Dam, it may be covered. I'm not sure if my understanding is correct. I think we should focus on construction sites. Commissioner, I think Ms. Christine Fong's questions should be directed to the specific policy bureaus. We may not be able to answer them today, but let me say this. If we have construction works being undertaken, regardless of it being indoors or outdoors, it would be regarded as a construction site and it will become, under the legislative amendments, a no smoking area. I want to ask about 37121 in particular. We have the transfer areas of the Lime Rock Tunnel Plaza being covered. So at the time the Changlam Tunnel had works being undertaken, will we have the Changlam Tunnel covered? Commissioner, I would ask the member to ask the Transport and Logistics Bureau, because I believe it was with coordination that they covered the specific premises. I don't think the question is related to our legislative amendments. All right, I think Ms. Christine Fong can follow up on this with the other bureaus and departments. That's the end of the second round of questions. We have had in-depth discussions about the Labor Department's responses. We'll end this part. Let's move on to clause-by-clause examination. We will look at the three pieces of subsidiary legislation. The legal advisor wrote to the administration regarding legal and drafting matters for the 3 pieces of subsidiary legislation on 1st of June, please refer to LC paper number CB brackets 1580/2026 brackets 04. I will also ask members to refer to the administration's response to the letter CB brackets 1603/2026 brackets 01. We will scrutinize the Chinese version. When we're scrutinizing the Chinese version, I will invite the legal advisor to remind members on specific provisions to note and the related legal and drafting issues and provide their opinions on the specific matters. And if members want to speak on particular provisions, they may press the request to speak button. We have 3 parts to scrutinize. Let's first look at the construction site safety amendment regulation 2026. I ask members to refer to CB brackets 682/2026 brackets 01, and we should look at clause 1. I will invite a representative from the administration, Mr. Ho Wang, Chief Occupational Safety Officer System and Support of the Labor Department, to brief members on the provisions. Thank you, Chair. Let's look at CB brackets 1580/2026 brackets 03. Let's look at 001. We will look at 224. We will basically repeal the existing Regulation 53 and put in place a new Regulation 53 to say that the contractors must take all reasonable steps to make sure no one is smoking or carrying lighted specified smoking products or light the specific products and use nickel lights. Contractors breaching the amended Regulation 53 will be fined a maximum of $400,000. I would also draw members' attention to Clause 2, or is it Regulation 2, about the definition of smoking products and specified smoking products. All right, thank you, Mr. I will ask the legal advisor to speak. Thank you. I would like members to note 3 points about the amended Regulation 53. Basically, under the amended regulation, contractors have to make sure no one is smoking in construction sites, and this is applicable to all construction sites. That is, all construction sites that comply with the definition in Chapter 59I. So if an area is designated as an exempt area, as we will see in Legal Notice 55, contractors will still have responsibility to take all reasonable steps to prevent people from smoking in the areas. Let's talk about a specific example. If there is a domestic unit where there are fitting out works being undertaken, if one is residing in the unit, the contractor still has responsibility to make sure no one is smoking in the unit. I also want members to note the following. The contractor has to take reasonable steps. There are 2 types of contractors. One, the main contractor, or any contractor that has direct control of the works in the construction site. So basically, it's main contractors and subcontractors. I would like the administration to talk about if the reasonable steps to be taken will be different for the different types of contractors and what the specific steps are. We actually asked about this in our letter. That is paragraph 4A. Members would like to would want to refer to that as well. About the third point, the definition of specified smoking products is in brackets 2 of amendment regulation at the moment. And here we specifically said lighted specified smoking product. We wrote to the administration to ask if alternative smoking products that are consumed not by lighting, would they be covered? And the response from the administration is for alternative smoking products are not consumed by lighting such products, they are not covered. I would like to have the administration talk about the justifications and detail what kind of alternative smoking products would be consumed not by lighting such products. I also want to point members to Legal Notice 55. No one can smoke in construction sites, and it would include activated smoking products regardless of whether such products are consumed by lighting such products. Thank you. Anything to add, or would you like to give a response, Labor Department representatives? Chair, I would just like to make a specific point about what the legal advisor said earlier, the very last point, with construction sites being no smoking areas. The personal responsibility would cover all smoking products, but for site management personnel, they only need to make sure smoking lighted smoking products will be prohibited. And this is a specific design because for workers, whether they are choosing to harm their health by smoking, it's their choice. We are trying to make sure contractors have management responsibility to manage fire risks. That's why we made this distinction. And for the Labor Department, we would make sure contractors will regulate smoking conduct. This is our design. I can see Ms. Christine Fong has pressed the request to speak button. Where in the clause-by-clause examination, I ask member to focus on the specific issues, I will assign a 2-minute time limit. I only have a very simple question. As the legal advisor asked, if we have different types of contractors, main contractors and subcontractors, will you initiate prosecutions against the main contractor or the subcontractor? Say if an employee smokes, the employee of a subcontractor, will the main contractor be held responsible? Commissioner: thank you, Chair. If we initiate prosecutions, the main contractors and the subcontractors both have management responsibilities. As for whether whom will initiate prosecution against, it would depend on the degree of management responsibility. And the subcontractor, if it has direct management of the employee, we will initiate prosecutions on this. For the main contractor, it really depends on the circumstances. So even if we initiate prosecution against the main contractor, it may be of a different offense or of different circumstances. All right, we have 2 other members who would like to ask questions on the specific provision. Professor Chen Wing-Kwong. Thank you, Chair. I have some concerns, just like the legal advisor did, about e-cigarettes. Did the administration specify e-cigarettes and alternative smoking products in the relevant provisions? For a worker consuming e-cigarettes or alternative smoking products, will their acts be regulated under the specific provisions? Well, for some e-cigarettes, no nicotine may be needed, but I don't think this is specified in particular in amended Regulation 53. I think you should make clear of this. Thank you.
就係
Well, I think there is a clear distinction. When we talk about the act of smoking by an individual, we mean to say that no smoking of any tobacco product is allowed. But when it comes to the contractor's responsibility, we specifically refer to smoking products that require naked light. So that depends on whether the e-cigarettes require the use of a naked light. So let me give you an example. Imagine there is a tobacco product that comes in the form of a patch. So your body takes in nicotine after applying the patch. Then no naked light is required. It is a tobacco product, but it's not a designated smoking or specified smoking product, and hence the contractor does not have any responsibility of barring any worker from using it. Right, 53(1). The contractor responsible for a construction site and a contractor who has direct control over the work in the site must take all reasonable steps, so on and so forth. So my question is this. Can you tell us about the differences of reasonable steps to be taken by the former kind of contractor and the latter one? Reasonable steps depend on the nature, size, site management approach, works procedures of the construction site. What constitutes a reasonable step may be different in each case. So specifically, we need to consider the circumstances and the responsibility of the contractor in taking reasonable steps. And like I said, it is an evidence-based approach in determining reasonableness, and it is also the threshold that the Labor Department must meet in initiating prosecution. Mrs. Thomas So. A follow-up question, as Chairman just now mentioned, what constitutes a reasonable step depends on the size of the site, the circumstances, the works that the contractor is responsible for, so on and so forth. Now, in the guidelines, will you illustrate with different examples the point so that contractors will be in a better position to know exactly what the administration is referring to, how they expect to fulfill their responsibility, what is meant by a reasonable step? Commissioner, yes, we will consider that. Thank you. Right, so much for this provision. Labor Department, please go on. Now, you went on to Section 53 very quickly just now. So would you like to just read out the first amendment in relation to construction site safety regulations? That's actually in Section 1. CB bracket 2 682/2026 bracket 01. In fact, I mentioned it. We're going to repeal the existing Section 53, and we will be adding 53 bracket 1. And then we should look at the marked up copy. Well, that's point 2. In fact, point 1, construction site safety regulations amended. Perhaps you should explain that as well. Right, construction sites safety regulations cap 59I are amended as set out in sections 2, 3, and 4. Right, please continue. Well, I explained section 53. We're going to repeal section 53 and substitute it with the following. 53. Prohibition of smoking, etc. in construction sites. 1. The contractor responsible for construction site and the contractor who has direct control over any construction work in the site must take all reasonable steps to ensure that no person smokes or carries a lighted specified smoking product in the site. And B. No person uses a naked light for lighting a specified smoking product in this site. 53 bracket 2. We provide a new definition. Smoking product and specify smoking product in subsection 1. There are definitions. Please go on. For Section 3 of the amended regulation, Regulation 68 will be amended, offences and penalties relating to contractors. Members may wish to turn to CB bracket 1580/2026 bracket 003, page 0002. Thank you, Labour Department. Legal Advisor. Thank you, Chair. In relation to the proposed amendment to Regulation 68, offences penalties relating to contractors, I would like to draw members' attention to the relevant offences. Now, the administration clarified with the LSD that this is a strict liability offence, and that is the prosecution will not be required to prove the intention. And the administration also supplements that Section 18 under FIUO of Cap 59 which provides a defense will also apply here, and that is for the defendant to prove that all reasonable steps have been taken to discharge that responsibility. And I'd like to invite members to refer to Section 4.8 of the LSD's letter. Thank you, Legal Advisor. Any questions from members or any supplement from the Labour Department? If not, please go on. Right, we covered the 68 just now. 68 bracket 1 to repeal 53 bracket 2 and to substitute that with 53 bracket 1 and then 68 bracket 2 bracket B. 53 bracket 2 will be replaced by 53 bracket 1. Please go on. Section 4 of the amended regulation, Regulation 71 amended offences by other persons. The following will be repealed. Any order made under Regulation 53 bracket 1 or who contravenes Regulation 54 bracket 2. And this will be substituted with Regulation 54.2 only. Right, no question from the legal advisor or members. Legal advisor or members, would you like to supplement on the English version? Thank you, Chair. In relation to Construction Site Safety Amendment Regulation 2026, the Legal Services Division have not identified any irregularities in relation to the Chinese and English versions. Right, let's move on to the next one, and that is Smoking Public Health Ordinance Amendment of Schedule 2 Order 2026. Members are invited to make reference to paragraphs 1 and 2 of the legal notice 55/2026. Mr. Ng from the Labour Department, would you like to walk us through the provision, please? 2 legal notices will be tabled by the administration into the Legislative Council. Let me explain those. The first one is legal notice 55 in relation to Smoking Public Health Ordinance Amendment of Schedule 2 Order 2026. I'll just call it the amendment order. Section 1. This order comes into operation on the 17th of July 2026. As for the content, we should now move on to the marked up version, CB Record 1580/2026, Record 01. Let me invite members to turn to page 0002. That is point 3. 1 of the amendment order. Schedule 2, Part 1, Division 1. To repeal as defined in Part 3. That's in relation to the area of premises prescribed for destination of no smoking areas. Right, Section 1 commencement, you covered that. This order comes into operation on the 17th of July 2026. Please also read out Section 2. Smoking Public Health Ordinance amended. The Smoking Public Health Ordinance Cap 371 is amended as set out in Section 3. And the details are set out in the Section 3, which I covered just now. Thank you, Mr. Ng. No questions for the time being. Let's go on. Members, we go back to the marked up version, page 0003. That is Section 3.2 of the Amendment Order, Schedule 2, Part 1, Division 1, after Item 21, to add number 22, a construction site. That is to say, the construction site will be a designated non-smoking area. Right. Mr. Dennis Long, please. Chairman, since a construction site is also included in the schedule, can you explain the scope of a construction site? I want to know how broad it is. Or can you tell us what is not defined as a construction site? I need clarification. Right, but in fact, we had a lengthy discussion about the meaning of a construction site. We also raised some examples. But Commissioner, please briefly answer Mr. Leung's question. I would invite Mr. Leung to go to our response to the Secretariat's paper, specifically Item 1. In relation to the definition of a construction site, we also set out the point, and we gave some examples. Ms. Christine Fong, I understand the meaning of a construction site, but like what Mr. So said, will they be included in the guidelines or the code of practice? Show the industry what scenarios you're talking about for reference, because the judiciary will refer to our legislative intent. This meeting is recorded on tape, so could you include that in the code of practice as well?
I believe the Commissioner said earlier he would consider the suggestion, say for reasonable steps or site boundaries, they would make clear of make clear the examples in the guidelines. Chair, we can include specific examples in our work for publicity and education. Thank you. Would the Labor Department representative continue? I would ask members to refer to pages 4 to 7 of the marked copy. I will give a general summary and then I'll go with the different clauses. We would have for Division 3, we would change the items, and for Clause 3, we would change the specific schedule areas. And then for the designated exempt areas in construction sites, they will no longer be exempted. The third amendment relates to exemption of living areas in construction sites. We will also include items 2 to 12 in Part 2A. We will change the numbers of the items to 1 to 11. All right. I will now go back to here, adding of the schedule 2 of Part 2, an area described in Part 2A of the schedule other than any part of it that is a construction site, and 3, any part of a construction that is situated in occupied domestic premises or occupied private quarters. And in Schedule 2, we will repeal the original Item 2, Type 1, private quarters that's defined in Part 3 and substitute it with Part 2A, areas described for purposes of Item 2 of Part 2 of this schedule. We will have, say, specifically Item 1, Type 1, private quarters. And in Schedule 2, Part 2A, we will number items 3, 4, 5, 6, 7, 8, 9, 10, 11, and 12 as items 2, 3, 4, 5, 6, 7, 8, 9, 10, and 11 respectively. For Schedule 2, Part 2A, Item 2, we will repeal the part as defined in Part 3. In Schedule 2, Part 3, we will repeal in this schedule and substitute it with one interpretation of Schedule 2, 1 in this schedule. 9. Schedule 2, Part 3, Section 1, 1. Definition of Type 2 private quarters, paragraph C, after Part 1, add the expression of this schedule. 10. Schedule 2, Part 3, Section 1, 1. Add in alphabetical order construction site has the meaning given by Regulation 2.1 of the Construction Site Safety Regulations, Chapter 59I. Occupied domestic premises means any domestic premises that are being occupied by their residents for residential purposes. Occupied private quarters means any Type 1 private quarters or Type 2 private quarters that are being occupied by their residents for residential purposes. 11. Schedule 2, Part 3, after Section 1.1, add 2. For the purposes of Item 3 of Part 2 of this schedule, if there is more than one separate household unit in any domestic premises and any part of a construction site is situated in any of those household units that is not being occupied by its residents for residential purposes, or B, any part of the domestic premises that is open to and available for the common use and enjoyment of the residents of the premises. Then, even if any of the household units in the domestic premises is being occupied by its residents, for residential purposes, that part of the construction site is taken to be not situated in occupied domestic premises. Thank you, Chair. Thank you. Legal advisor and the members have no questions on this. I want to ask if members or the legal advisor has any comments on the English version. Yes, legal advisor. The Legal Services Division has not found any contradictions between Chinese and English versions of the legal notice. Thank you. Well, we would have the meeting and at 6:45. We only have one part left. It should be quite short. We shouldn't need too much time. But as per the rules, I will extend the meeting by 15 minutes. Let's move on to the last part, fixed penalty, smoking office offenses, specification of authorities and public officers, amendment notice 2026. We should scrutinize this part. I will invite members to refer to clauses 1 and 2 of legal notice 56. I'll ask the representative from the Labor Department, Mr. to brief members on the specific clauses. I would ask members to refer to the marked up copy for CB brackets 1580/2026 brackets 02. I would ask members to refer to page 4 of the marked up copy. I want to first talk about the commencement date. The notice will come into operation on 17th of July 2026. Clause 2 is about fixed penalty, smoking offenses, specification of authorities and public officers, notice being amended. Chapter 600B, that is amended as set out in Section 3. Let me talk about Clause 3 for the schedule that is to be amended after the entry relating to Authority Director of Leisure and Cultural Services, adding 1 in column 2. It would be Commissioner for Labor. In column 3, it would be Occupational Safety Officers as defined by Section 3(1) of the Occupational Safety and Health Ordinance, Chapter 509, basically designating the Commissioner for Labor to be the authority and Occupational Safety Officers to be public officers for an offense under Smoking Public Health Ordinance. And for the schedule, after the entry relating to Authority Director of Leisure and Cultural Services, we will specify the Commissioner for Labor that and Occupational Safety Officers as defined by Section 3(1) of the Occupational Safety and Health Ordinance, Chapter 509. All right, we have no questions from the legal advisor or members. We are just including Labor Department officers in the scope. All right, Ms. Christine Fong has some questions. Thank you, Chair. I want to say, as I said earlier, we will designate the Commissioner for Labor and Occupational Safety Officers as defined in the Occupational Safety and Health Ordinance to exercise powers under the ordinance, just like the officers from the LCSD and Housing Department. There are no geographical constraints, right? Commissioner, in terms of powers, there are no geographical constraints, but then Of course, we have our different professional foci. When there is some sort of overlapping, we will make sure to make referrals and conduct joint operations. I think that much is clear. The officers have the power, but in actual enforcement, different departments will have coordination so that officers will go to different premises for enforcement. Yes, Mr. Dennis Leung. Thank you, Chair. I note in the schedule we have included occupational safety officers. The other categories are mostly civil servants. I want to ask if occupational safety officers in their current training would have the work relevant to this at present. Well, occupational safety officers should be civil servants. They're not referring to, say, site safety officers or safety supervisors. This is actually quite a large grade in the labor department. I think that much is clear. Occupational safety officers from the labor department. If there are no other questions, I will now ask if members or the legal advisor have any comments on the English version of the notice. Legal advisor. Thank you, Chair. The Legal Services Division has not identified any contradictions between the Chinese and English versions of LN 56. Thank you. All right, we have looked at all three parts. The Secretariat has not received any proposed amendments from members or the administration before this, but following the rules, I will ask if members would like to propose amendments, and I would also like to remind members, if you wish to propose amendments and if you want the subcommittee to consider the amendments, you must propose such amendments before the 18th of June noon. You have to email the proposed amendments to the Secretariat so that the administration can give a written response. If the administration would like to propose amendments, the administration should submit them to the subcommittee for consideration as soon as possible. I believe the administration has answered all questions raised by members. There is probably no need for the administration to issue another response, but if you wish to give another response, you may provide such response for circulation among members. I would now talk about the legislative timetable for the two pieces of subsidiary legislation that will undergo negative vetting in accordance with our decision made at the last meeting. I will move a motion at tomorrow's council meeting to extend the scrutiny period of the two pieces of subsidiary legislation to 15th of July 2026. And regarding the proposed resolution, the administration said they would move the resolution at the council meeting on 15th of July, and I will make an oral report at the House Committee meeting on 26th of June on the work of the subcommittee. Regarding the three pieces of subsidiary legislation, the deadline for giving notice to move amendments is 8th of July 2026. I think the timetable is quite clear. If there are no questions, we'll move on to the second agenda item, any other business. There is no other business. I would like to thank members for being here, and I would like to thank the Commissioner and the team for supporting our work of scrutiny. Meeting adjourned. Thank you.